I, the juror, Shatoya Crawford, am in favor of the plaintiff. On case number 1, hospital implements new minimum necessary policies for telephone messages. Because the plaintiff specifically told the hospital staff to call job for any update on health information. The defendant disregarded requests and left patient information with someone other than the patient herself, which was not the instructions that was given to her. The defendant violated HIPAA laws and a breach of confidentiality, which occurs when a patient's private information is disclosed to a third party without his or her consent. Because of this error, this has placed the plaintiff in an uncomfortable position with her daughter, the healthcare organization, as well as the doctor, which could permanently tarnish the organization's reputation. Patient confidentiality and privacy rights are a serious matter. Access to patient information is for people that are assigned to provide care. Each staff member must review and abide by all the policies that implement those policies that address patient and employee confidentiality. Staff members who violate HIPAA provisions may expect corrective action ongoing from coaching to termination, depending on the extent of the violation. All workforce members have a duty to protect confidential information. The HIPAA privacy rule permits healthcare providers to communicate with other people regarding their health care. To reasonably safeguard patients' privacy, covered entities should take care to limit the amount of information disclosed on an answer machine, as well as permits covered entities to disclose limited information to family members, friends, or other persons regarding an individual's care. In this case, the defendant left detailed information that the plaintiff did not want disclosed. This was poor professional judgment. Such disclosures are in the best interest of the patient and should limit info, which the defendant did not see the best interest of the patient, which she disclosed the information. Like the plaintiff stated, such measures should not occur, and all staff members need the necessary training when applying those protocols. According to HSA 1988, this act applies to health service itself and generally prohibits from disclosing information that could directly or indirectly identify a patient. If they do disclose information, they have committed an offense under HSA 1988, which they may be fined up to $7,380. In addition, the HRA 2001 and RA 1988 confer statutory privacy rights on patients whether they are treated in a public or private facility. Both acts set up complaint processing for individuals which the defendant believes confidential information about her was unlawfully disclosed to a third party, and their health information was not properly handled. The three rules of HIPAA include the HIPAA privacy rules, which protects the privacy of individuals' identifiable information. HIPAA security rule sets national standards for the security of electronic protected health information. HIPAA breach notification rule, which requires earned entities and business associates to provide notification following a breach of unsecured protected information. The patient safety rule protects identifiable information being used to analyze patient safety events and to improve patient safety. These laws are put into place to prevent breaches like the one in this case. Therefore, the defendant is guilty of breaching of confidentiality and within the patient's information, which I am in favor of the plaintiff.